Yes.
One mention, Miller.
Yes.
Morning, I had made a file two memos. The matter was listed. Plus, a director for listing of the last Friday. Could not listed because court could not take held.
Friday.
Yes. But I have today filed memos. So very urgent matter. Let's me call this matter tomorrow because two documents let's was short for last time. But the matter has not been hired. That challenge the cognizance order. They are all.
Cognizance order, what urgency?
No, it's urgent, sir. But they are now they have issued summons to appear. But that is they are scheduled caste persons.
Then what?
They're scheduled caste persons. It's a scheduled tribe person.
You please give the memo.
I will give in memo.
We'll just check it out.
But last one fixed date for hearing. Last already fixed date, but could not list it because of the matter court could not wait.
We'll check it.
Compromise matter is listed.
My lord.
But day after tomorrow, I
We'll check
think
it up, sir.
Item 30.
the urgent of the date fixed to list.
I'll check it out.
Serial 38. Compromise matter. Both the parties file.
I'll take it up. Don't worry.
My lord.
Senior is there. Leave this space. When seniors are there, yes.
No.
My lords, item number 43, subject to your lordship pleasure, can be taken up little early
Today,
today.
I'll take it up.
Oh, great.
If you have patience, then no problem. I'll try to take it up.
No, lordship, then cannot change. I'll try it. I will take it up.
I will have to take it up now.
I'm grateful. I'm grateful.
Definitely. Yes.
My lord. I may be pardoned, lordship. I'm just filing a petition. It is in defect list, lordship. Actually, tomorrow a student has an exam. He's a law student. 6th semester exam is there. He has been arrested in a confessional statement for a 379 case, lordship, in Paradip case. Yesterday, 41A was not compliant, and he was forwarded, remanded to the custody. I filed an application before the learned magistrate along with admit card, exam schedule, everything. He is a continuing student, lordship. I said, you arrange at least he will give exam. Let him stay in custody. He should be.
You want to appear in the exam.
He want to appear in the exam. 7 तारीख
Take it up tomorrow.
Tomorrow is the exam. Last item I am filing the petitions. I am giving it.
Get it.
That
Appear in it. Today, yeah?
Today.
Take up today.
I'm giving the
End of the board.
Yes, lordship.
Maybe it's little late, but I'll take it.
5 o'clock, lordship. Obliged.
Yes.
Item 100, my lord. It's a passing of criminal proceeding. Your last occasion, it was listed before the lordship.
Yes.
Your lordship kindly remember that matter when your lordship has.
What do you want?
I want to take off, my lord, because my IA is pending.
Why do you presume that it will not be taken up?
100 is there, my
It
lord.
will not be taken up, then at the end we'll see. But I'll try to just go through only urgent matters. I'll take it up. Rest of the matter I'll adjourn it next tomorrow or day after. This week we'll adjourn. Huh? It will be rolled over for tomorrow.
Obliged, my lord.
Very urgent matters I'll try to take it up. Like
Obliged.
the one which the gentleman that man.
100. My item is 100, my lord.
Yes, that's
Yes, 119. I have talked already with my learned counsel for the vigilance. So
you want the adjournment?
I have already taken the counsel.
Adjournment. No problem.
My last 119, 119.
There is it. It's all right. No problem.
The interim order may continue.
Entry order will continue. Yes,
Item-
no.
Item 117, I am seeking an adjournment, lord.
Adjournment.
Again.
Oh, 17 adjournment.
117.
That is the best thing you can ask today.
Great, of course.
Yes. Adjournment. Adjourned already. Entry order will continue unless I say otherwise. Unless I vacate it or say otherwise, it will continue. That is the standing instruction to.
That case, the case, but the surveillance was dismissed for default. Thereafter, that has been restored. And after restoration, first date has been formed. So,
All right. You are seeking adjournment, entry order to continue.
fine.
Ah.
Item 30.
No. Serially you call. Serially you call.
Item 36.
It will come, wait. Well, I'll take it. Yes.
I may be pardoned, my lord.
Yes.
Item number 44, it is a regular appeal in which 3 years conviction is there. It is to be admitted regular appeal. My mother has expired, my lord. So I pray that this matter may be
43.
44. Yes.
Yes.
My name may kindly be reflected and free copy be granted. Regular appeal, 3 years conviction. My
3 years coming. Who is appearing? No, he is appearing for vigilance. Who is appearing for the petitioner? Nobody is appearing for petitioner so far.
So I pray that my name may kindly be reflected.
44, I think. Item
Yes.
44. If anybody appears, then I'll pass the same order and I'll pass on to you.
Yes, my lord, I will be obliged, my lord.
I'll record your presence. Don't worry. You are free.
Yes, my lord, free copy.
I'll
be
record.
granted. Free
I'll
copy.
record
be
your
granted.
appearance.
Okay, my lord, I will be obliged.
Okay. Right down.
Item 75, take it up next tomorrow.
75 adjourn करो.
74.
74 adjourn. हाँ.
Auto
ठीक है. Let us start the meeting.
Item 2.
2.
Order dated 7/12/2021.
Yes.
Taken by the APGM Baleshwar Manor. Where the present petitioner who is a old senior citizen, who is a retired post officer. He has given some.
Please use the mic. Not able to hear. Sorry. Here.
The present petitioner is a retired person, my lord. He has engaged opposite party number 2 as the contractor. He has stolen some checks and he deposited in the bank. After knowing the fact, the petitioner lost the affair before the complaint case, and arising out of that,
Is a
FIR has been
complaint,
registered.
is a complaint case.
It's a NI Act.
No.
Cognizance has been taken in an NI Act. Prior to that, the present petitioner has lost the affair. Were registered and under section 420 and 471, 72, 73. Thereafter, he has lost the complaint case and where cognizance has been taken.
498A 307. Which item?
Item 2, man.
Item 2.
NI Act, man.
Pratap Chandra Mahapatra.
Yes, man.
Not NI. Acha, complaint. Oh, it's NI Act, huh?
NI.
I'll have to issue notice.
Yes,
Issue
ma'am.
notice to opposite party.
OP2.
Opposite
OP2,
party.
man.
OP2.
Stay for further post.
You are the accused. You are the accused in NI
Yes,
Act. NI Act matters generally.
No, because prior to that, I have lost the affair. After.
Maybe that may be your defense, sir. See, the statute says that within 6 months it has to be completed. If you get a stay, then it goes on and on. You serve it, I'll put it next week.
Okay.
Short date.
Item 3.
What is the check amount?
723 lakhs, man. 7,500.
If you deposit,
I have,
if you deposit 20% without prejudice, I'll stay.
because I have,
See,
I have
140,
engaged.
143A says that you have to deposit 20%. Will you deposit? I'll say.
Because I
Then come
old
next
man,
week.
my doctor. Old man.
You can't have both.
Similar,
Have the cake and eat.
similar matter. Another check, item 69. The defect is removed. AG government of
69 also, 138
yes. Same.
no notice and both the matters
Yes.
in the same day. Okay. Next, 3. Yes, sir.
Right, item 3 and there. If you are civil fine, he is one of the parents was filed the application. And the husband, the father of the boy,
So 498A.
right. But in fact,
You are the father.
I am the father of the boy. The mother has already been granted the interim protection by virtue of the order of this honorable court. It is the case.
So this is, you are challenging what? The cognizance.
We are challenging cognizance in a case where the daughter-in-law filed the case. FIR has been lodged.
What is the allegation against you particularly?
Allegations are all against the husband. In fact, there is a matrimonial dispute.
Is there any chance of settlement?
So a lot of effort has been made. She joined the husband and they stayed together. Then the brother-in-law intervened, actually created all the problem. And thereafter, if your lordship looks at it, all the orders I have annexed. So this restitution of conjugal right application was filed. Then application section 97 was filed with the court, directed them to reconcile.
Mr. Ragada, wife and husband, they fight. Wife and husband, why the parents are involved? Let them fight.
Notice.
In fact,
I'll issue notice, but he's
Gupta's
71
case-
year old.
71 years.
Issue notice to the opposite party number 2. Mr. Ragada accept notice for the state. This matter is arising out of a matrimonial discord. and the petitioner is the father-in-law of opposite party number,
OP number 3, no?
OP number three.
Two, my lord, two.
Two, OP number two. He is challenging the order dated 15/3/2000. No, sorry, order dated 20th May 2017, whereby the Leonard JMFC Basta in CT case number 583 of 2016 is taken cognizance of offense under section. What are the offenses? What are the offenses?
In the other matter, I think further proceeding has been stayed. my lord.
No, what are the offenses?
490 tape 406 506 34 IPC
Right,
section
right.
4 DPR.
Issue notice, the issue notice to opposite party number 2 till the next date of hearing, the proceeding pending before so and so, further proceeding pending before so and so is said qua the present petition.
Right.
Yes.
Item 5.
Yes. Yes.
May I please, Your Lordship? Lords, as per Your Lordship's last direction, the entire document that was collected by the IU in this case, I have filed that. Your Lordship permit, I will give a brief, quick recap.
I don't recall.
Lordship. What has happened in this case, my lords? Initially, a case was registered at Mangalabag PS police station
Yes.
for violation of provisions under the TOHO Act, Transplantation of Human Organs Act. And during the course of investigation, the petitioner was arrested from Vishakhapatnam and brought to Cuttack. Thereafter, Lordship, the wife of the petitioner, challenging that said arrest as illegal, filed a WPCRL before this honorable court. Now, my lords, in that WPCRL, this honorable court declared the arrest illegal and held that no case under the TOHO Act can be registered at Mangalabag PS, and the police does not have any authority to investigate a case under the TOHO Act. Lordship, in this regard, Lordship may have a glance to page number 43,
43.
my lords.
Yes.
Below para 38.
Notice was issued in this case?
No, Your Lordship.
No, my lord.
May I read, my lords, the relevant?
I am just issuing notice.
My lord. Only Your Lordship issue notice there.
I'm just issuing.
My lord.
Yes.
Lordship.
Item 8.
Yes.
May I please?
Opposite number 1. My lord, notice 2. Opposite part number 1. My lord.
Yes. Notice open partner. Yes.
May I please? My lord, Annexure 1 at page 8 is under challenge against the rejection order arises out of a petition filed by the petitioner under section 457 CRPC for release of the seized money of rupees 73,000 some odd, which has been seized by the all police.
Cash of 73.
My lord.
742. Yes.
In fact, at the time of arrest of the petitioner, I had seized the said cash from the possession of the accused person, my lord. And the said seized money was kept by the petitioner for the treatment of his ailing mother, my lord.
What is the
And
offense?
the
What was
seized
the offense? What was the offense?
offense, my lord,
Offenses are?
initially the FIR has been registered 498, 323, 506, 307, 294 and 4 DP Act.
Who are
and
you? Who are you?
I am the husband, my lord. And the charge sheet
In a, Mr. Ragada, in a 498 case, some cash is seized.
My lord.
Why can't it be released?
My lord.
What will you do with that cash?
My lord, whether that my lord, my lord, the amount, my lord, that has been seized, whether it belongs to petitioner, my lord, is unable to, my lord, the
He says that it
convict
was
the
kept
court,
for the treatment of father.
my lord.
my lord, he unable to convince, my lord. That after, my lord, the
Let us see the impure order. Let us see the impure order. What is the reasoning given?
My lord.
Where is that? Impure order, sir. Which page?
At page 10, conclusion that the accused person is the real owner of the said seized cash,
Hmm.
rupees 73,742 only. Further, the value of the seized cash will not deteriorate in future till final disposal of the dear cash. Hence, on the above aforesaid grounds, the petition filed by the accused person stands rejected, being devoid of any.
The petitioner is the real owner.
My lord. But since my lord
This is the
the,
finding, you just see.
my lord, since my lord the,
So it is difficult to assess, it is difficult to arrive at a
my lord,
conclusion.
that is the
Man,
How will you establish that you are owner?
set up. And since you
man,
for
It is seized from you, it's all right.
my lord. So,
Where where is it?
your lordship may kindly see the
Found that the cash of
seizure list, my lord.
of different divisions have been seized by the IO at so and so in connection with so and so. It was seized from where?
At a PS, my lord. Police station,
From your position, from your pocket.
my lord.
From whose pocket?
Petitioner's pocket.
Where? Show me. Show me where from the money was seized.
My lord. Your lordship may kindly see at page 16, annexure 3, my lord.
See,
My lord.
I am releasing it. What is this? Let him give indemnity bond. Just see.
My lord, on production.
Page 16 seizure list. Just see.
My-
It is written here. The case, see, during the course of investigation, I seized the above cash on the possession of Tushar Kant Samar. Yeah, what is this? Samar.
Samal. The bid
Samal, Samal.
My lord.
Son of so and so, so and so. If it is seized from his possession, he is entitled. Cash, ownership of cash, but how will he establish?
And then your lordship, he will adequate indemnity bond and other my lord.
The trial court will.
And if the court require, my lord, he will
Yes.
give the cash.
Trial court will impose the conditions. Right on. The order dated 31/3/2023. The application moved by the petitioner under section 457 CRPC for releasing of the cash of rupees 73,000 73,742 73,742 rupees seized from his possession at the police station in connection with the PS case number 384 of 2022 has been rejected. Has been rejected. The which court is this? Yes, JMFC Owl by impugn order has rejected the application of the petitioner, whereby by recording by arriving at a conclusion that the accused could not prove the ownership of the cash recovered, cash seized. However, the seizure report places on record as Annex 3 indicates that the cash was seized from the possession of the petitioner in the police station. Keeping in view the fact that the cash amount was seized from the possession of the petitioner, I am inclined to allow this petition and directly release of the cash to the by the court below on the court below. Accordingly, the petitioner is directed to move appropriate application report cash. If such application is moved, the same shall be considered favorably and release the cash by imposing the condition as made in 15 proper in such application.
Hon'Ble.
Allowed. Yes. Item 10. Yes.
May I please, your lordship? My lord, this is for quashing of a criminal proceeding
Yes.
wherein the offences are under section 498, 506, 323 and other allied offences. Kindly have a glance over page 17, last
Please
para.
use the mic.
My lord, my lord.
Yes.
Kindly have a glance over
last para of page 17, my lord. My lord. Their marriage has already been dissolved on mutual consent, and the petitioner have settled all their, my lord.
The matter is
Compromise- compromise-
Yes, my lord.
compromise-
Issue notice.
My
all
lord.
this. All. Issue learned counts, but the petitioner submits that the present matter is arising out of a matrimonial dispute and parties have settled their dispute. Pursuant to the settlement, the petitioner is the husband.
My lord.
Petitioner and the opposite party number 2 had applied for dissolution of marriage on mutual consent. The same has already been allowed. Issue notice to the opposite party, returnable next week. Next week.
Further proceeding may be stayed.
Next week I'm keeping. Bring her, I'll quash it. Why further proceeding? Bring her.
Further proceeding stay thao se
Nothing will happen, sir.
saying
Bring
appear
it.
se further proceeding stay hele se manu gas ke appear kar ji chos da.
We settle ही follow करी.
Ana settle hichi na again demo decree ta again deichi.
Further proceeding. Further proceeding so states
Till next date.
till next date appear.
Again.
But file the requisite and bring her.
My lord.
Yes. Next.
Okay.
12. 12. The registry has pointed out certain defect which has not been cured by the petitioner. By way of last opportunity, liberty permission is granted to the certificate of the defect. Please give an answer. Yes.
14.
14. Yes. Defect. Yes, 14. None appears in the interest of the seated judge. Next.
16.
16
Yes.
years lordship. Lord, here, the offense is under section 138 NIS. I was added as an accused in the trial court. My lord, I did not receive the notice for which NBW was issued. On subsequently coming to know regarding the issuance of NBW, I appeared in the lower court below and filed an advance petition to recall the NBW and I filed an application under section 205 lordship. My 205 application has been rejected, for which I am for the lordship. And NBW has been issued.
What is the check amount?
Check amount, your lordship. Check amount, your lordship.
You have not filed anything except the inquiry.
3 lakhs, your lordship.
3 lakhs. Why are you unnecessarily litigating? Pay the money and finish it up. Yeah. Fix up. I'll fix up installment. Call him.
No,
You are spending more money in litigation.
no, but honestly speaking, at present, the petitioner, the accused, who is the petitioner, your lordship, his wife is from Rim Hamlet, is there in Kolkata. The petitioner is accused from Kolkata.
Maybe you have a personal problem, but the fact of the matter is the check has been issued, you have to pay it. I am issuing notice, bring him. We'll see. Issue notice to the opposite party. Returnable last week ago. 20 record. You bring him, we'll see.
Sir, after 26, he is working in Kolkata.
Huh?
Anything after 26, they will be returning on 28th to Kolkata, from Kolkata.
Petitioner.
My lord. Anything after 26.
What is the role of petitioner? You are there. I am issuing notice, bring the respondent, we'll see can it be settled or not. I am just issuing notice. He may not come.
Okay.
You are there, you can take care. Yes.
17.
17 also the same.
Same, notice. Pudi kuch rakhe devo. Yes.
21.
Yes. 21, na? None appears for the petitioner in the interest of justice and judge. Yes.
22.
Yes. I have already adjourned. Yes. Yes, yes. Tell me.
Petition is the
What is this? Oh, in this petition, you have, except FIR, you have not filed anything. FIR was registered on January 24. Investigation is going on, it seems. Is it? Investigation is still going on.
Yes, my lord, I have no information. I have not.
Your bail might have been rejected. That's the reason you are here.
No, my lords.
Then
No.
why are you?
My lords, I am a in-laws, my lord. I am a government servant, my lords.
Maybe, but
Yes, my lord. I am not involved in this case, my lords. I am the.
how
but
would
the
I
pit-
know you? Except FIR, you have not filed anything.
Yes, my lord. I am
How would I
questioning.
know whether you are involved or not?
But sir, only I am praying for a quashing of FIR, my lord. Because, my
How
lords.
can I quash, sir? Mayor, FIR is filed and you want quashing of FIR.
Investigation going on.
Investigation is still going on. It is premature, right? The petitioner seeks to withdraw the present petition, reserving his right to approach this court if cause of action still survives at the appropriate stage. With this liberty, petitioner is disclosed. Wait, they may file final form also. You never know. Why are you coming at this stage creating
My lord,
problem?
because I am a government servant, my lords. Honestly, my lord,
I know the 498 cases are like that.
the decision, my lords.
After a charge sheet is filed, you file the 482, I'll entertain and call them and try to
My lord,
settle it.
this regards, my lord, I have. This
Judgment will do unnecessary. I'm giving that liberty to
Yes,
wait for some time. And police also knows what kind of cases are.
yes, my lord. The many cases, my Supreme
I
Court,
know.
my lord, says that the 70% false, my lord.
Police
Cases
also carefully, nowadays police doesn't file the charge sheet like this unless something is there. Maybe against husband it may be filed. The other-in-law may be let up. Wait. Yes.
22.
Yes.
22.
Yes.
22 item, my lord. Last action is to direct the State Council to obtain instruction about final charge sheet, my lord. Though the instruction, my lord, obtained, my lord, that is not, my lord. I want to, my lord, another urgent matter.
Mr. Ragada, seeks one more opportunity to serve instruction regarding the status of the case. Urgent next week.
My lord, 9th रे posting टा अच्छी से जो interim order अच्छी आउटे time bits हैं.
Is there any interim order?
My lord, you lordship have directed that
There they will file time bits.
time bits.
You file for Mr. Naik, learned counsel for the petitioner submits that he would move appropriate application would report below
On 9th.
giving adjournment owing to the fact that the matter is sub judice before court.
23.
Yes. Non appears in the interest of justice. Yes.
25.
Yes.
24 Arjun.
24 withdraw.
25.
I am for opposite party, my lord. The matter relating to 138 of NI Act, my lord, both the London and Court below rejected the prayer of the petitioner, and only to intention of prolong the matter, they are filed petition before your lordship, my lord.
Notice was issued.
Not notice was issued. I am so motive.
What is this petition, by the way?
My lord,
Challenging what? Cognizance order.
My lord,
Cognizance order.
cognizance order.
Have you moved application under section 143A?
No,
You should have moved application.
my lord.
20% deposit.
Your
What is the
lordship,
check amount?
kindly see para 4 of the impugned order, my lord.
Page number? Yes. Para 4.
Para 4. Impugned order.
Yes. During the course of hearing.
During the course of hearing, the Lord and Council for the revision petitioner would contend that the impugned order is unsustainable. According to the Lord and Council, no valid reason has been assigned by the Lord and JMFC Jaipur to reject the petition of the petitioner. The Lord and Council would submit that the opposite party has failed to show that the revision petitioner issued check to discharge any liability and for enforceable debt or liability. So the complainant was incompetent and cognizance of the under section 138 of NI Act shall not should not been taken. So the impugned order be set aside and the complainant be dismissed after quashing the order of cognizance, my lord. Next page, my lord. On the contrary,
petitioner is not there simply in the interest of justice. Don't appear for opposite party. None appears for petition. Next week. Next week.
tomorrow, my lord.
Not
Intentionally prolonged matter.
Already there are many matters. We'll see.
Date fixed.
You are respondent. The petitioner is not coming. Next time he will not come. I'll dismiss it.
Date may be fixed.
Date will give. Yes.
26.
Here it is a case, my lord.
where the wife has filed an FIR after taking the child for temporary custody for 10 days and did not return the child thereafter, though court has directed to the SP to produce the same, and thereafter filed an FIR against me stating that we are abusing with the father and grandfather are abusing the
Why have you
grandchild.
not implemented the?
I have implemented, notice may be issued. I have
Where
implemented.
is that? You have not implemented.
Yes, yes. No, sorry, my lord. Sorry.
That's what.
I am permitted to implement, my lord.
These are
I thought that
family dispute. You must implement.
But the FIR allegation is very serious, man.
FIR, it is not the
Very
FIR.
serious.
It is the
Anyway,
one which
I'll-
has filed after taking.
Anyway, I'll keep it next week. You implement her. We'll see.
Yes, my lord. I will implement in the meantime. I will file an IA
Yes.
to that effect also.
Next.
Your lordship permit me if then I can.
The consular petition seeks to implement the informant oblique victim. In the present case, is the opposite party.
Victim, not victim, wife, my wife, informant.
Only informant. Informant. The opposite party number 2. We may do so within by tomorrow. Lease the matter next week. Yes.
27.
And do it tomorrow.
Yes, tomorrow I will do.
Yes. 27.
27 matter has been settled between the parties, my lord. Kindly taken up next week to appear the information.
When comes to the petition submits that the matter has already been settled between the parties. They would be appearing before this court to depose the claim and lease the matter. Next week. Yes.
28.
Yes.
May I please, Your Lordship? One of the petitioner challenges order under annexure 2 series at page 26, Your Lordship, may peruse.
Yes, sir.
Order dated 31 January 2024.
31 January.
Yes, Your Lordship.
Yes.
Here, for a moment, Your Lordship, may peruse previous order at page 25. On 19/1/2024, accused person Akshay Kumar Ghade is produced through BC and remanded till 1/2/2024, awaiting FF, awaiting final form, Your Lordship.
Yes.
Thereafter, the case was posted to 31st January 2024. Accused person Akshay Ghade is produced through BC and remanded till 13/2/2024, awaiting FF. Thereafter, latter, though it was not stated latter, but order dated same day, 31st January 2024. Charge sheet number so-and-so under section so-and-so.
Received.
Yes, sir. Peruse the FIR, CS remand report.
What is wrong in it?
Charge has been taken on that day, Your Lordship, without giving opportunity for
Cognizance.
filing. Sorry.
Cognizance.
Yes, Lord. Sorry,
What is
my
wrong?
Lord. I am challenging charge, Your Lordship. Order dated 11/3/2024 at page 27, Your Lordship.
3/2000.
11/3/2024 at page 27, Your Lordship. Similarly, Your Lordship may peruse previous order dated 27/2/2024 on the last part of 26.
Yes.
Page 26. The accused UTP accused also Akshay Kumar Ghade is produced BC remanded till. No subject has been fixed whether it is posted for charge or anything. On
After cognizance, only charge can be framed.
My lord, the petitioner has not
Where
been.
it is not written that it listed for charge doesn't mean that the order goes.
The statute said 207 shall be complied with, my lord. Police paper.
Tell me after cognizance what happens?
Police paper is to be
It might
supplied.
have been given because he is in custody.
My lord, Your Lordship may peruse.
Raj read FIR so and so. Hence the cognizance is taken to produce against the accused person.
The accused person is now in jail custody, put up on the date fix.
Now in jail custody. Since he is in jail custody, the entire paper might have been given. It is not.
No, my lord. No, my lord. That has, Your Lordship, that has been stated in the order dated 11/3/2024.
11/3?
At page 27, Your Lordship.
Yes.
Accused UTP, Akshay Kumar produced from custody, remanded STK, PP is supplied. On that day, PP was applied and charge has been framed, my lord. The petitioner has not given any opportunity to file discharge, Your Lordship.
My lord,
In the first half, the PP was supplied, and in the second half, charge is framed.
And even
And
PP
he is
has
in
not been.
custody.
And
Who is
even
appearing for whom? I don't know.
and even PP has not been supplied till date, my lord. But
That's the problem. He is in custody. In the morning hour, you supply the papers, and in the afternoon, you frame the charge.
Because orders are so this same manner.
Issue notice to the opposite party. What is the offense?
My lord, the offense is under 420, 294,
What is
506.
the allegation?
My lord, allegation is that I have taken money and
from-
did not give him land. That is under annexure 3 at page 29. I have already.
Why have you not implemented the informant?
My lord, because it is GR case form
You
for
forget
that.
about GR case.
I
You
will.
have taken money, you have implemented.
Your lordship may
I'll
permit
pay
me.
money and I'll quash it. Finish.
Your lordship.
Why this charge, everything will be. How much you have taken?
It is stated that 97 lakhs I have taken, but it is not the fact.
How much you have taken, you tell me.
I have
According
taken
to you.
15 lakhs and given the sale deed was executed and ROR has been.
You are admitting that 15 lakhs you have taken.
Yes, your lordship.
You deposit that.
I have given, your lordship may pay
Deposit
annex
that.
3.
I deposit that money. I'll send it to mediation. I'll stay the proceedings.
I have already sold that land. For that reason, I have taken. That land is under annex 3, your lordship. The sale deed.
You have taken money. You don't want to pay. That's
Behind that,
Your
lots of
lordship-
things are happening, my lord, normally. Because what amount has been mentioned in the RO, deed of sale deed. And behind that, many persons there exchanging the money and different manner.
I'll set aside the charge order.
Yes.
The court has to give an opportunity to have heard.
Yes.
And thereafter.
Yes, your lordship. I will produce
straight
these
away set it
documents.
aside.
I will produce these documents.
I'll set aside the order.
Yes, your lordship.
Because the same day it has happened.
Yes, sir.
And a fresh opportunity will be given, and thereafter, if the charge is made out, made out.
Yes, your lordship.
That's better. It's better.
Fine. Yes, your lordship.
Petitioner is agreed by the order dated
11/3/2024.
11/3/2024, passed by JMFC 4
5,
Bhubaneswar in connection with CT case number 1895 of 2023, corresponding to Khandagiri PS case number 620 of 2023, whereby charges were framed against the petitioner for offense under sections. What is that?
420, 294 and 506 IPC, my lord.
506 I. Okay. Mr. Mishra, let counsel for the petitioner, submits that in the on 31/1/2024 in the morning, the petitioner is in judicial custody. While he was in judicial custody, he was produced through VC and remanded on 31/1/2024. The petitioner was produced through VC and was remanded till 13/2/2024 in the afternoon session and 24. On that day itself, the copy of the charge sheet was supplied to him. In the afternoon session, the court proceeded to frame charges.
My lord, cognizance. On 31st.
Oh, 31st. No, charge kahan gaya abhi?
30, page 27, your lordship. 11/3.
Galat likhna. Hold it. No. Likho. Puro likho. Mr. Mishra, then comes for the petitioner submits that on 11/3/2024, the petitioner was produced in custody. And the matter was remanded till he was remanded till 23/3/2024. On that day, the charge sheet was supplied. Copy of charge sheet was supplied to him. Later on in the afternoon, the court proceeded to frame charges against the petitioner. Therefore, he contends that no opportunity was granted to the petitioner. No opportunity of hearing was granted to the petitioner while framing charges. He is agreed by the state order and hence this petition. I tell you the proceeding. Place on record Agent 2 series. It indicates that the on 31/1/2024,
11-3.
24, the petitioner was produced in VC and remanded to judicial custody till 13/2/2024, awaiting final form, awaiting final form. On the same day, in the afternoon, police appears to have filed the charge sheet. Immediately after receiving the charge sheet, in the afternoon session, the trial court had taken cognizance of the orders. Subsequently, the same thing, the trial court has repeated the same thing on 11/3/2024. In the morning session, the petitioner was produced before the court, and a copy of the charge sheet was given to him. In the afternoon session, the charges were free. Therefore, I'm of the conditional review. The petitioner was not afforded appropriate opportunity of hearing while framing the charges. Hence, the order dated 11/3/2023 is set aside.
24
and
euros.
is remanded back to the trial court to afford the adequate opportunity to the petitioner for hearing on charges. But it is made clear that the petitioner shall not seek any adjournment, unnecessary adjournment in the petition for unnecessary adjournment. With these observations, petition is allowed. Yes.
My lord, my contention is that PP has not been supplied till yet, Your Lordship.
You tell all this.
My lord. But it has written.
It is written, but you tell adequate scrutiny.
Your Lordship, one line may added that my contention.
Further submit that although the order reflects that PP has been supplied, but till date he has not received it.
Deeply obliged, Your Lordship.
2023 and 2024.
24.
20.
I will pardon to mention. Item 23.
Huh?
Item 23.
26 already adjourned.
23, Your Lordship. 23.
In between, why are you mentioning? I don't entertain, you know that. You are not there, I simply adjourn it.
So that
Next week you will get the date. No problem. But please don't mention in between. 29. Yes.
My lord, I pray for next week.
Sorry?
I pray for next week.
Adjourn. Yes. 30.
May please. The present petition is challenged the order dated 5/2024. The London's SDGM reject my complaint petition on the ground that the complaint petition is premature, man. On that line, my lord, only
the bar council member will be speaking so loud, slowly. How will you lead us?
Lordship, my petition was dismissed
You
for.
are a leader, you should speak loudly.
Only my limited prayer is that Your Lordship giving liberty to file against second petition before the learned
What
trial.
is this? What is this?
My petition was dismissed for on the ground that that is petition premature, my lord.
It was dismissed.
Yeah, dismissed on the ground the complaint petition filed is premature. Learned FS court directed again you file a fresh petition
30
before
plus
the
15 days ପରେ ଦବା କଥା notice ତାର 2 ଦିନ ଆଗ notice ଟା ଦେଇ ଦେଇଛି
out of fresh file.
for which after
130.
ଆଜ୍ଞା 138 and
Only liberty,
Timelines are given in the statute itself.
only your Lordship given liberty to file a fresh petition.
I will not give liberty.
Direction ହେଇଥିଲା ସେ FS court ସେଇଟା କହିଥିଲେ.
And କଣ କହିଛନ୍ତି?
Last year କହିଲେ କି
Liberty second
Last-
complaint is filed within a period of
filed.
2 months from the date of this order. We request the trial court to dispose of the complaint within a period of 6 months. What is this complaint is about?
Similar fact, my lord. Petition was Facts on.
I'll simply issue notice. Ex parte order I'll not make.
yes, ma'am.
138 matter. Issue notice.
Yes, ma'am.
If file rate ରଖିଦେଇଥ. I'm just issuing notice. Let it
Yes,
stop.
ma'am.
Okay. 31. What is the check amount?
1 ଲକ୍ଷ 30,000
30 ଲକ୍ଷ.
ଲକ୍ଷ 1,30,000
ନାଇଁ 10 ଲକ୍ଷ ନା?
ଲକ୍ଷ
10 ଲକ୍ଷ ଟଙ୍କା।
10
10 ଲକ୍ଷ।
10
10 ଲକ୍ଷ.
I am the complainant.
You are the complaint.
ଆଜ୍ଞା।
Okay.
ତାକୁ ବି notice ହେଇନଥିଲା ସେତେବେଳେ
Let
ବି।
him come. Let him come. Yes. 31.
Item 31, my lord. It is a matter of 130 Act The check has been issued by the company, but the company has not added as accused. So unless the company has added as accused,
No, you are the accused.
I am one of the accused, but the check was issued by the company.
Company.
But
Company is not.
not, my lord, I have also filed a similar judgment.
Oh, I know that. Show me the complaint.
What one is notice has been made, sir?
Page 9.
9, huh? Show me where the company has issued.
My lord, company has not added as party.
Where does it say that the company has issued the check?
My lord, page 16.
16, 16.
16, the check.
Check, huh?
For Ores Ispat Private Limited.
1 minute, sir. 1 minute. Authorized signatory. What is this? Limited. Private limited.
Private limited.
Issue notice.
I'm filing the judgment.
What will the settled position of law?
But I have filed the IA, my lord.
Okay. And counsel for the petitioner says submits that the subject check has been was issued by what is this company's name?
My lord, Ores Private Limited.
Huh?
Ores
Ispat Private Limited. Private Limited. However, the complainant has impleaded the petitioner being a
authorized signature of the company. Authorized signature of the company.
Petitioner being it has been included as an accused, being the authorized signatory without including either the director of the company or the company Issue notice to the opposite party. The retainer will also further proceeding is also state. Yes. 32.
32, my lords, I'm appearing on VC, my lords, maybe not.
Yes.
I'm appearing on VC, my lords. My lords. Lords, in the present case, the petitioners before my lords are the father-in-law and mother-in-law of the...
Your voice is cracking.
My lords, am I audible?
I'll take it up tomorrow. Come.
No, my lord, then there is the question with the question of entire criminal proceeding, my lord. And under section 498 323 506 34 406, my lord. But my lord, the CRLMC 779 2024 is pending, and your lordship has fixed to here at
pending.
That was for the husband, which Milords were pleased to issue notice and stay the proceedings.
To come together, my lord.
Okay. Along with
at 8/5/24 along with the CRLMC 779 by 2.
Milords may also issue notice in this because this is the father-in-law and mother-in-law.
That's right. One CRLMC is pending for quashing of the same FIR by the other accused. So I'm taking it. I issue notice and tag it.
Milords, and there's an IA for stay of proceedings, Milord.
In that matter, stay has been granted.
Stay has been granted, Milords, because Milords were also...
Where is that order? Where is that order? Show me the order.
Tagged along with, I have given the reference, Milord. It is CRLMC number...
Order.
779 of 2024, Milords, CRLMC number.
Which page?
Milords, the order in that CRLMC hasn't been annexed with the present petition, Milords.
You should have. How would I know?
At page number 2, I have given the reference. I have given copy of the order also, Milords. As per directions of the registry, a copy of the order in that CRLMC has also been supplied, Milords.
Is there any order?
Milords, prima facie in the present case, the FIR allegations were all false. And Milords were pleased to stay the proceedings in that case also because...
1 minute, 1 minute.
The allegation...
1 minute.
Milords. Grant stay in only exceptional circumstances, Milords. This is one of the...
CRLMC 779 of 2024.
Yes, ma'am.
Against the husband, huh?
Yes, my lord.
Arpan Kumar Patro.
Yes,
Milords.
Same order, tag, eh?
Yes, ma'am.
Same order, tag. Issue notice, tag.
I'm grateful, Milords.
33.
My lord, petitioner challenges the order dated 27/7/21 for cognizance as well as the NBW by the annexure 3, my lord, page 18.
Sorry?
Challenges the order of cognizance dated 27/7/21 as well as the NBW by the Annex 3 at page 18, man. Of the
I'm not going to interfere in cognizance. I'll pass the NBW order. You go and appear.
Hmm.
That NBW, you were on bail.
41.
Petitioner was given 41 notice at the time of investigation. Then the charge sheet was filed showing you as a absconder. Charge sheet was filed showing the petitioner as an absconder. Subsequently, the court below has taken cognizance for the offences under section
379 by 34.
379
34.
34 on 27/7/2021 due to the absence before the court below. The trial court has issued NBW 15/11/2022. 500. Yes.
34.
Yes.
Has been filed on the ground of compromise. And in the evidence also, they have stated that they are staying in one house. And after attending the age.
What is the offense?
Offense 376, my lord.
376.
Yes, my lord. Notice should have been go.
Staying together.
Staying together, but they will be married after attaining the age of 18. Now the 17 is the age of the girl.
POCSO is also there.
Yes,
6 POCSO is there.
They are staying.
What is the allegation? 164 is there?
164 I have annexed, man.
Show me what are the allegations.
Your lordship may see page 26.
Yes, read it. You read it.
The ground is that the petitioner is facing a prosecution for the offense under section 109 of the penal code. Her husband was facing prosecution for possession of disproportionate assets. The only allegation against the present petitioner is that.
Are you putting forth any defense?
No, not defense. The only
my judgment will cover
the ground. ଆପଣଙ୍କ case cover କରିବ ଯେ the only ground here in additional ground is there that the husband of the petitioner died prior to the cognizance, who is the principal accused. And since this is a case of possession of disproportionate assets, as per the section, the offense cannot be proved against him because the offense of possession of disproportionate assets becomes complete not only when the prosecution proves that the assets possessed by the person is beyond his known sources of income, but on the failure of the accused to explain. So the offense only becomes complete when the accused is unable to explain. The accused is not there. The accused cannot explain. So the offense cannot be proved against the person.
He died.
He has died. And so the prosecution does not lie. There are two decisions, one of the Bombay High Court exactly on the same point and another of the Andhra Pradesh High Court.
How will you prove disproportionate principal accused?
So far as this petition is concerned, death of the principal accused, there are so many judgments also, including the judgment of this division bench judgment of this honorable court, that death of the principal accused in the DA case will not inure the abettor to go away.
Stage of trial?
Stage of trial is the cognizance stage.
Therefore,
cognizance stage,
it
is also there.
Beyond that, if some evidence has already come against the principal accused, then one can understand. It is the cognizance stage.
Before cognizance.
No. Supreme Court judgment is also there.
Show me.
I'm sorry. So far as this case is concerned, so far your lordship judgment is not covered because your lordship kindly see page 65.
So that's a different story altogether.
That is not because petitioner saying that almost all the assets stands in the name of the petitioner, and petitioner taken a plea that I have income tax assets, I am paying income tax, so and so, and I have acquired those assets. So he has to prove. And another.
At the beginning, I asked whether are you putting any
no.
This
is the main.
If you are putting a defense, then
this is the main ground. This is the main ground. This is the main ground that the offense
you file your
against the accused cannot be proved.
Number of judgment that the division bench of this
I'm just issuing notice.
Arati Behra case that has been clearly established that and other judgments of the Honorable Apex Court also there. And relying to that judgment, this honorable court has also held that no, she has to face the trial.
To the extent she is putting her defense, she has to prove it.
Proof.
The question of abatement only comes when there is an offense.
Offense will not die.
When you
Offense will
cannot
not die.
prove the offense,
The
what
date
comes
of
the
the
question
accused
of
offense will
abatement?
not die. I am giving number
What
of
comes the
judgments, sir.
question of abatement?
There are number of judgments. If Lordship will allow time, I will file.
Issue notice. I'll keep it on 20th. 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 Huh?
Okay.
Come with the judgment and yes.
36
See जो judgment हो जो copy दे देवे ठीक है.
Yes.
36 lordship on the ground of compromise lordship this serial lordship file for postponement of the proceeding lordship that is cognizance order
Four.
both parties are present. My lords. It is squarely covered lordship's judgment lordship. They have now married and two children is there present lordship.
Four posts is there.
Informant, informant,
Yes.
wife with child lordship all there.
He is the court commissioner. He will examine. Mr. Maharaj, we are the court commissioner. Ask that girl whether she
Copy the
Next, informant hotel my lord. The allegation is my lord. I am so and so. ମୁଁ ଗତ 19/4/2001
have you settled the dispute?
No, my lord. In speculative lordship, 10 Gopalpur.
What is the stage of the
Stage of now investigation is continuing, my lord.
So then how can it was?
My lord, your lordship kindly peruse the additional affidavit. Yes, I will refer to all the things.
That's the reason you are here.
Yes, my lord. Your lordship kindly peruse the additional affidavit. Additional affidavit, my lord, in the date of occurrence. Your lordship kindly peruse.
All these things at the investigation stage, how can I pass?
My lord.
Merely because your bail application is rejected, therefore you file 482.
No, my lord. What happened, my lord? The 307 किसी made out होने. Thereafter.
अरे made out होती नहीं, police देखियो ना मुँह देखिए.
Yes, no, simple report also that. Another
you don't
thing, my lord.
understand. It is even if it's simple injury, police will file under. You don't know what is the 323, 226, 307. How do I know?
My lord,
Police may file 323 also.
My lord, separate मुझे जाऊँ नहीं. More additional affidavit file that at the date of occurrence, petition was absent. तंकर जोड़ी जो service करते हैं.
Plea of alibi will also be tested in the trial.
Yes, ma'am.
Not that at the time of once the FIR is lodged, you get plea of alibi. I'll go into all these things and pass the FIR.
For your kind consideration, ticket
fundamental. Why should
what happened, my lord?
Anyway, you show me what you want.
If what happened, my lord,
where were you on that day?
My lord, your lordship kindly peruse though. Annexure, my lord, additional affidavit.
Yes.
Service certificate and private employee. This certified that the Mukesh Kumar Naik, the popular so and so, Odisha has been employed Wilson Service Private Limited Company on dated 1/12/2022 to 12/10/2023, working as a security head. His service in the company is about 1 year. He also performed.
How do I know this is a fake certificate or correct certificate?
If your lordship directed,
I'll go and ask the police.
Yes. If it's genuine, then I have no case. If it's genuine,
how will I check it? Shall I go to the company and ask?
Company authority will write, my lord.
Shall I go and ask?
No, if in doubt, my lord.
All police has to see. You give this paper. I'll give that.
Yes.
I'll give that liberty to you.
Yes,
you give it to the police.
And enter.
Police will.
My lord, well, no, 307 is not made out to be modification is.
How can I go into
no grievous
No,
order.
that is sure. That is no grievous, my lord. But the right side of the scalp, my lord.
I don't know anything. You, the police will look into it. I don't want to tell anything at this point.
अरे सेदिन नचल
on the date of the petition was
लागू जो छुट्टियां
by way of petition affidavit he placed on record various documents whereby he suggests that in fact petition was not
छुट्टियां जिनसे तो मेरी एरर लागू जो तो किसी लागी बोल खाली छुट्टियां मोटे धरछो जोडी बड़ होई जे धरनु
all these issues. However, liberty is granted to decide to produce all these documents before the police. and police, the investigating officer is at liberty to look into, take into consideration all the documents placed before him and placed before him and take the necessary steps.
In the meantime, no coercive action. No coercive, null police.
Along with this, what else you have to give, you know that. Along with documenting, give something.
Obligement.
38.
Yes.
My lordship, passing a proceeding on the ground matter in compromise.
38, huh?
Both the parties are present, madam.
Parties are there.
I am for the opposite pen number 2, my lord.
It is that the investigation stage. 307, injury report, show me. Show me the injury report. Injury
My
report.
same day, he discharged.
What is, show me the injury report.
I have not written, not obtained, my lord.
Injury report, अच्छी आपने पाके. It is a 307, at least I need to know what the word.
Both are
Injured
present.
person saying that he same day he discharged from the hospital, my lord.
Ask him, where was the injury? At least I need to write, it is a simple injury or previous hurt, whatever.
कितने दिन हॉस्पिटल में रहते थे? कुछ दिन रहते?
तबीयत कुछ खराब नहीं।
Okay, day after tomorrow, just verify what is the injury. He doesn't know the Orissa also. We don't know.
Dispense with both the parties.
Huh?
Dispense.
Why?
Personal circumstance.
He is an accused. Why VIP treatment? Let him come day after tomorrow. We'll see the nature of injury.
Yes.
If it is very grievous injury, then the cost will be heavy. I'll cost it, but heavy cost. After all, you have beaten him. In 307, generally it's not cost.
Yes.
But if the injury is simple in nature, generally. So let us know at least. Day after tomorrow. Every day keep it on record. Day after tomorrow. आप ठीक पहुंचा देवे injury report टिके नहीं है just over phone also you can get it and if you Mr. Patel, if you can get injury report also please.
Yes, I'll try.
It must be a simple injury.
Yes.
Looks like.
39. May plus questioning of the criminal proceeding on the ground that the coacted persons face trial and they have been acquitted.
You are absconding.
Yes, madam. That's it submitted against 4 persons and 3 of them have faced trial and they have been acquitted. The offense is 395, madam. 395.
395.
The annexure 3, page 40 is the judgment and finding at
TI period was conducted.
not conducted.
All the 3 of them are acquitted.
Yes, madam.
Show me the relevant part of the judgment.
Relevant part, madam,
Where
page
the-
50, paragraph 7.1.
Yes.
So far as the identity of the alleged accused person is concerned, the informant PW2 has deposed that he knows the accused Bapi alias Gajendra Patra. He has been acquitted, who was working as a salesman in his shop at the relevant time, and prior to 1 year of the incident, he had joined in his shop as a worker, but does not know the other accused persons. But he has not mentioned the name of the said accused Bapi alias Gajendra Patra in the affair. But surprisingly, the PW3, who is the informant's wife, has denied to know about the present accused persons, including the accused Bapi alias Gajendra Patra, who is alleged to be the employee of her husband.
All these evidences are quite I'll protect you. Go and appear. Expedite the test.
And the absconding
That is why.
NBW. Yes.
No, you are absconding.
On the-
You have declared proclaim offender? Why not? Next week. What IA? You have been absconding for such a long time. Now for these 3 days you need protection.
Yes.
You could, yes.
Next. 40.
May I please? The 100 people came to the house of the informant, the annex 1, page 9. The petition is not named in FIR. Down to the FIR page 9, start from page 8. Chasangara village, about 100 people. They came to the house of the informant and took out the bullet motorcycle, other the color TV, gas, everything. And on the charge sheet, the IO file showing the petition absconder. No TI pirate, no recovery, no accused statement. Not named in FIR. 22%.
Charge sheet, what has come against you? Let us see.
That is at page.
Statement of any witness.
In Lordship, I can say that page 37,
Page 37.
Yes, my lord. During course of investigation, the spot case was visited. Complainant and other witnesses were examined. Also, the Chasangara village under the Balugam place is headed by Gangadhar so and so arrested the accused person so. And the assembly, the trespass, the house of the complainant as took away the engaged so filed the vehicles, articles so. And nothing has been mentioned regarding the inform the petitioner. Only because you are the villager of that particular village has been charge sheet limited. There is no other material.
Hey, where are the 161 statements?
Let's me call for the case date. Now the warrant is 81 years of age, the petitioner. In the case of the 2010, 14 years have elapsed.
I'll quash the warrant.
No, no, if you will 81 or say age of you will go to they will take into custody because now the warrant is issued against him. You'll also
What happened? Go repeat question. All
they were
all of them are on bail. Must be
on bail.
I'll record everything. On parity, will be I'll quash the NBW, allow you to go and appear and move the application.
No, there is no
on parity, you will get the bail. What is the bail? You are 81-year-old.
81.
I'll write those things. You will get the bail. That's better idea. Okay?
Yes, ma'am.
Right off. In the present petition, petitioner is seeking petitioner is seeking quashing of the FIR and consequential proceeding arising therefrom. Therefore, FIR numbers also there. Mr. Rautrai, petitioner submits that in the FIR the petitioner name was not there. However, the charge sheet has been filed against the petitioner and all other
22 others
villages. Petitioner is an 81-year-old man. Now, by the order dated NBW, we should which order?
22 to 21, my lord. Last order, my lord.
It is 22 to 2020.
Last order, my lord. Page 40.
Court of JMFC Banapur had issued NBW against the petition. On instruction to cover the sector, declined to appear before the court on or before June 15th June 2024 and avail remedy under law. He further submits that taking into consideration the fact that he is the petitioner is an 81-year-old man, and the fact that all the coercive persons have already been granted bail, he is entitled to bail on the ground of parity and parity as well as on merit, as well as on merit. I'm not inclined to entertain this prayer in the present proceeding. However, liberty is granted to the petitioner to move for bail before the court below on the grounds as stated above. And if such application is moved, the same shall be considered the same day. Same day.
But in case of rejection, my lord, the case of 395
Same day.
by the courts below, my lord. Now, because case of 395, magistrate has no power to, my lord, grant bail. We'll go to the higher forum.
Same day. And
By both the courts below.
same day by both the courts. This first hour, second hour business, I don't.
And both the courts will on the same day, my lord. No issue, my lord. Until then, warrant may not be executed, my lord.
Warrant state.
Yes.
Cost for the warrant cost.
Cost.
NBW is cost.
15th will be holiday, my lord. So you'll also fix Saturday, 15th.
On or before, you go before. On or before June, 15 June. Anytime you can go.
That is Saturday, my lord. Yes, my lord.
Anytime before that you go.
Yes, yes.
41.
Yes, how my lord next week.
Yes.
On behalf of Ekya Sahu, my lord. Akshay Sahu.
Sorry?
On behalf of Akshay Sahu next week, my lord.
Adject.
42.
May I please, your lordship?
Yes.
Like here, my challenge is the order under annexure 5, my lord, rejecting my application under section 205 CRPC, my lord, and refusing to allow me to be represented through my pleader, my lord. My lord, here.
1 minute. That's the five. You see? 42. 42, na?
42.
There or not? Where is the? Yes.
If your lordship will kindly have a glance at the cost title, your lordship will find the petitioner number 2 is a 72 years old man, my lord. And he is the chairman of GIET University, my lord, at Kanpur.
All other accused are very young, accompanying him.
No, but three is also 64 years. And he is the vice chairman of GIET. And one is the registrar of GIET who is 58 years old, my lord.
Yes.
My lord, now the case is, my lord, pending in the court of the learned judicial magistrate first class at Padampur, my lord, which is 20 kilometers away from this place, my lord, the Gunpur, where they are officiating in the capacity of chairman, vice chairman, and registrar in the GIET institution, university, my lord. My lord, now, no, each person, because of their nature of duty, they are, my lord, doing, my lord, it is very much difficult for them to.
What are the offences?
Offences are under sections, my lord. My lord, 120B, 121A, read with 41CA of Unlawful Activities Prevention Act. My lord, here the case is, my lord, these petitioners on the particular day, my lord, that is in the year 2008, they were traveling by a car carrying 12 lakh rupees, 12 lakh odd, my lord, to hand over to the carpenter for the purpose of construction of the college building, my lord. My lord, now on the way, the police, my lord, apprehended them with the allegation that they suspect that because the
Hawala money.
ଏମାନେ ଏତେ ଟଙ୍କା ଧରିକି ଯାଉଛନ୍ତି ତେଣୁ
Hawala.
ଏମାନେ ନେଇକି ଯାଉଛନ୍ତି ସେ ମାଓବାଦୀଙ୍କୁ ଦବା ପାଇଁ।
We don't know.
That is the whole of the allegation, my lord. This only under suspicion, my lord. If your lordship will kindly have a glance at
That's
the
right,
FIR.
but I'm not tasting that.
No,
You are a grievance.
I am not there, my lord. I am not on the allegation part, my lord. My question is, my lord.
Your grievance is
Only 205 has to be, my lord. I must be allowed to be represented by my pleader
you are on
instead
bail.
of
You are on
instead.
bail.
I am on bail. On the spot. I was arrested.
Why can't you avail the? You can move 317.
No, 317 and 205 stands in total different
That's
footing,
right,
my lord.
but you can be represented.
317, every day I have to file an application, and unless I appear, the case cannot proceed.
You have enough money to engage lawyer.
Engaging lawyer is different, my lord. Here the purpose of the very purpose of the criminal prosecution will be frustrated.
205 is not meant for these kind of people.
No, that is decided by the Honorable Apex Court, my lord. And this Honorable Court has time and again, my lord, has held that it is, my lord, the magistrate has ample discretion, my lord, to liberally consider the application under section 205.
The moment you say that it's a discretionary order, he has exercised discretion.
But that discretion has to be utilized in a judicious manner, not in a cut-short manner.
I'll issue notice. Let us see. You just see whether what best can be done.
My lord,
I'm just issuing notice.
And stay further proceeding because the
in 205, what are you talking?
The court below will
you 317 you move and
the court below will issue warrant.
No question of staying in a 30 petition. 305 petition you want
205 petition, my lord. Because, my lord, if your lordship, my lord, I will satisfy your lordship.
That maybe I'm examining that issue. That's not an issue. You can move an application 317 for one hearing or two hearing. How does it make difference?
My lord,
because your physical presence you want
yes,
exemption.
That is the only thing, and it will otherwise help the prosecution for disposal of the.
Had it been a ordinary offense, I would have immediately allowed. I know
Yes.
I am allowing all this thing, but since section 41 prevention of what is that? Prevention of
that is solely on the ground of suspicion, my lord. My lord, that is the prosecution case itself, my lord.
Prevention of
ମୁଁ ଟଙ୍କା ଧରିକି ଯାଉଥିଲି ବୋଲି ସେମାନେ ସସ୍ପେକ୍ଟ କରୁଛନ୍ତି ଏମାନେ ଆମେ ତାକୁ ନେଇକି ଦବା ପାଇଁ ଯାଉଥିଲୁ. My lord, even though your lordship unlawful activity they suspect because I was carrying money, they suspect that because such a huge amount was being carried, they are going to hand it over to the.
Where is the charge sheet?
Charge sheet is at annexure.
The charge sheet they might have said something.
My lord, your lordship may first come to FIR.
They forget about FIR. Charge sheet is filed.
Yes, charge sheet is filed.
FIR is on the basis of suspect. No problem.
Suspicion.
But after charge sheet, what they found?
କିଛି ନାହିଁ. Say same thing. Nothing is there.
Just check it up. The same.
No, one was filed in the year 2013, my lord. Where, my lord,
have you given declaration of
Yes, my lord. I have given the declaration. I have filed the copies of the orders also.
I'm keeping next week.
Then your lordship may say that I will file an application there. The court below will
issue notice to Mr. Mishra, land council petitioner submits that his client would move application under section 317 CRPC on the next date of hearing before the court below. If such application is moved, same shall be considered. Yes, issue notice. 43.
Yes.
Reopening review. Yes.
This will be listed after you.
Just see, we'll adjust and give.
But because the trial court is proceeding, 3-4 days time is granted.
Okay, that's good. You should be happy.
3-4 ଦିନରେ ଥରେ ଲେଖେ ରଖୁଛନ୍ତି.
You should be happy. Once you go, take a hotel and stay there. Your trial is completed.
Hotel
Why 205?
Hotel ର question ଏଠି ଉଠୁନି. Question ହଉଛି ଯେ if I go there, these students there, they will be affected because we will be unable to.
You are director, you are not faculty. You are the director. You are not faculty. The
chairman, vice chairman, and the registrar. Registrar is a very vital post there. He is to regulate everything.
Shall I give a direction that day to day proceeding and it will complete within 1
Nay,
month? And you go and
nay,
appear.
ସେଠି ଯାଇକରି ସେଇଟା appear କରିବା ପାଇଁ difficulty ବୋଲି ଆମେ କହୁଛୁ ତାପରେ ଏଇଟା ଯେତେବେଳେ କମିଟି ପଳେଇ ଆସିବ ଗୁଣୁପୁରକୁ then will appear my lord. This after this is committed to the court of sessions at Gunupur my lord, will appear there my lord. It is only for the purpose of magistrates court I am seeking for 205, not for the purpose of trial my lord.
We'll see.
Before this,
Yes, yes my lord, I have given the copies.
this is need to be verified.
There my lord,
That's the reason I am issuing notice.
there my
Verify.
lord, the cognizance order was challenged and this honorable court stayed the proceeding, but in the year 2023 disposed of the ultimately dismissed the application. So
Okay.
I am before your lordship for 205.
Yeah. Okay.
The lordship may say that
I have said that you move application. I have recorded.
until the
317 application.
until the next date.
317 application you have.
ସେଠି ଫାଇଲ କରିବି କିନ୍ତୁ until the next date your lordship may say the court will lack.
No question of stay.
Stay of only. 17 application file କରିବି. Till the next date your lordship has specifically case.
That's not. His clients have the problem in traveling to Raigada every time when the matter is taken up. Therefore, they moved an application under section 205, which has been rejected. He submits that the petitioners are.
No, my lord. What happened, my lord? I am here to assist the court, my lord. The moment the case will be committed to the court of Raigada, my lord, by the time they have to file, my lord, bail bond there, my lord, and assuring they will appear before the court of sessions, my lord. Then only case will be committed to the court of sessions.
They will assure through counsel.
They are already
They have in person.
No,
they are on
there.
the necessary.
They are also filed the bail bond, my lord.
They are on bail.
My lord.
We are
on bail, my lord.
Through counsel, they will file the bond and go to Gunupur. Why to stall it unnecessary?
The proceeding is.
He says that I'm recording.
My lord.
There is no problem in appearing in Gunupur after committal proceeding.
Yes.
And through counsel, they will file the bond, whatever necessary things are there. They are on bail right now. He submits that the petitioners are stationed at Gunupur. And once committal, once the proceeding is committed to the court of sessions at Gunupur, they have no problem in appearing before that court. Therefore, Mr. Mishra submits that till the committal proceeding is concluded and the matter is committed to the court of session, they may be exempt from personal appearance. Mr. Rogda, learned counsel for the state submits that at the time of committal, necessary.
Their presence is required, my lord.
No, he has to. They file a bond, na?
My lord. My lord.
45.
My lord. They have to file bond and giving, my lord, they will appear before the Court of Sessions, my lord.
At the time of committal proceeding, presence of the accused persons are necessary in order to file necessary bonds and assuring the court to appear before the Court of Session after committal. Mr. Mishra undertakes before this court that the petitioner should be appearing through counsel and complete the necessary requirement under law at the stage of committal, and assure the court that after committal they will be appearing before the trial court. Trial court, mainly the Sessions Court at Gunupur. With this observation, the petition is disposed of with the direction that the application under section 205, if a fresh application, if filed by the petitioner before the court of, which court is that?
It is JMFC Padmapur.
Also the same
JMFC Padmapur.
Considered in the light of observation made in this order. Disposal.
For that reason, my lord, the court below, my lord, mention presence of the accused persons is essential for commitment of the case.
ସେଇଟା ପରା ସେ appear କରିବେ through
Counsel
advocate.
committee.
Counsel will represent କଣ document.
Nowadays 313 statements are recorded in that. What?
Yes, my lord.
Pen drives are given. This is what is happening.
ମଝିରେ ଗୋଟେ
Sir is there. Sir is sitting. You ask him.
ମଝିରେ ଗୋଟେ
What is happening in Delhi? What is happening? They are giving 313 statement in pen drive. Take it and go to your lawyer and get a printout. Tell yes, no, whatever, and give it. That's what is happening because of the pressure.
ମଝିରେ ଗୋଟେ ରାୟଗଡା ଲେଖି ଦେଇଛନ୍ତି ସେଟା ପଦ୍ମପୁର ହବ ସେଟା ଯୋଉଟା କହିଲେ ଗୁଣୁପୁରରୁ ରାୟଗଡା ଯିବା ପାଇଁ ତାକୁ ପ୍ରୋବ୍ଲେମ ହବ ବୋଲି ସେଟା ରାୟଗଡା ବୋଲି ହେଇଗଲା ପଦ୍ମପୁର ହବ ସେଟା
ପଦ୍ମପୁରରେ ଚାଲିଛି ଆପଣଙ୍କ କେସ୍
ପଦ୍ମପୁରରେ କେସ୍
ରାୟଗଡା ଚାଲିଛି
ରାୟଗଡା ନୁହେଁ ପଦ୍ମପୁର
ଲିଖିବ ପଦ୍ମପୁର ଲିଖିବ ଚଲୋ
43.
Yes.
View taken on committal by my lords, aside, not in this case, is also the same view taken by the Honorable Supreme Court. Committal is essentially an administrative exercise, not a judicial exercise.
That's the reason I say that.
Yeah, exactly. I bowed out.
You're wasting time.
Yes, exactly. Precisely. Now, when it's coming to the facts of this case, I haven't seen a more gross abuse of the process of law, legal process, and defeating the ends of justice. But before I advert to the facts, kindly, my lords, may kindly turn to page 35 of the petition.
35.
35. Bottom.
Yes. What are you seeking, by the way?
My lords, let me tell you,
Passing.
I'm seeking quashing of the notice issued under 102 subsection 102. Purportedly under 102, there are a plethora of judgments, including judgments of this Honorable Court, that for compliance, some of the provisions of 102, when you seize or freeze an account of an accused, alleged accused, then you have to comply with certain preconditions. One is you have to inform the Ilaka magistrate. Second thing is that you have to give notice to him. Third thing is that you should not mechanically do it without recording any reasons.
Okay.
And not for an indefinite period. Telangana has held so. Karnataka has held so. Justice Aditya Mahapatra has quashed attachment because of non-compliance of the mandatory requirements of 103, 102 subsection 3.
Yes.
But before I come to that, my lords,
what do you want to show?
What I want at this stage is, my lords, a complaint was filed for a particular transaction. I am for the petitioner, and I am not even the accused. No FIR has been registered against me. Only an inquiry is being conducted by, initially though I got confused, his name is Tereskova, the IO. I thought Valentina Tereskova long back, so maybe. In any case, the IO receives a complaint, straight away sends a attachment notice, debit freeze, of my entire account. The admitted amount.
You are not an accused.
I am so far not an accused. No, no FIR is registered. And on the admitted facts, the amount is 90,000 only. And I am having crores of rupees in my account.
9 crore 80 lakhs.
9 crore 80 lakhs in my account. Everything frozen. My business is gone to bust. Is it not supposed? All right, I said. Today I'm ready and willing to say that a lordship may say that since the amount is 90,000, unless defalcated amount in the complaint, at all material time the bank will not allow me to withdraw that, including even interest 1 lakh. But how can you put a order open-ended indefinitely and the whole amount? That is a long answer.
You were showing 35. What is that?
Page 35 bottom. Just read for me, please, if you don't mind. It's too small.
Let's read, my lord.
Allow Sandeep to read.
It's small.
The letters are too small.
My lord, the email at the foot of the page 35 is from CCEOPS, that is the investigating officer's email ID,
Yes.
to LEA Communication at HDFC Bank.
Yeah.
And he says to the nodal officer, HDFC Bank, victim details so and so, transaction details. My lord has that at the last word, and then the page over.
That is the crucial.
Yes.
Transaction date 10th February 2024, and fraud amount, the third is
Fraud amount 90,000.
90,000 rupees.
90,000.
Yes. Yes.
What he does is,
Yes. And
then the notice that he sends is at page 34.
34 is the notice.
Notice by the officer,
middle of the page.
the middle of the page,
Nodal officer.
to the nodal officer, Suryodaya Small Finance Bank, account number so and so, that is my client's account. Debit freeze the fraudster's account till the inquiry is over. Entire account frozen. You can freeze my account up to 90,000. Or maybe with interest you can say, all right, 1 lakh.
What is the stage?
Nothing, no FIR is registered, nothing. Still pending, still
Not a
pending.
single paper has been added in this application. Only oral prayer has been made. A petition having no basis, it has been made before this on report. This is not a case where the application of investigation officer is to be considered. It's a case where 103 is to be followed by the investigating officer. So it is what circumstances has been followed. You know, on which basis they are rated, whether it has been.
So what is the stage of investigation?
Nothing, my lord. No paper is there.
So therefore,
No paper is there.
nothing is there. You have
And you-
frozen my account.
This application is not at all maintainable.
Why not maintainable? Notice is there.
Unnecessarily, we said email paper only. It's a application.
Yeah, where is the FIR? Where is the FIR?
Nothing, my lord.
No FIR. No, it is. We have not been issued even one notice. One
Then how are you making a statement that you are not an accused? There is no FIR?
No, there is no FIR. I am making it because otherwise a copy of the FIR on the 24th.
Because the expression used here in the notice is David freeze the fraudster's account. You may be the fraudster. According to them, you are a fraudster. means you may be an accused.
I say even if I admit, then what is the amount that is to be frozen till the
Investigation is on. It may increase, may decrease, may.
But they have quantified it in 90,000.
At this stage.
Yes, the complaint itself.
Many things.
I am issuing notice. Let us sort it out. Unnecessary work. Small
No
matter.
paper on which basis.
Where from he'll get instruction?
Sorry, madam.
Where from he'll get instruction? You have to tell something. FIR.
Defend number 3, call the defend number, call for the complaint.
1 minute. Let us see. He has to ask to some police station.
Yes, it's given now.
This is not a.
333.
It's a letter.
It is 1 second.
Get the reply. It's not reply.
Don't you have FIR?
OP3.
We went, he said no FIR is registered. We made that amendment.
We have made the amendment. We went and appeared before him.
No,
He
sir,
said,
problem would be mayor issuing notice will not make here and there.
Call.
So to give the FIR number or something.
there is no FIR.
Whether the account has been freezed.
Account has been freezed.
It is a reply. It has not been. The investigation officer has not.
The account has been frozen.
Kindly see. Last one lekha hai thi. And we are
This
waiting
is
for a
sent
reply.
from
This is
CCO.
this is the email.
Where is the freezing
This
freezing
one,
order?
number one.
That is the subject.
Ah,
Oh, yeah.
At page 34, my lord.
34.
Yes.
Yes.
The email, in the middle of the
What he
page.
says that these are email correspondence, it's not
Correspondence.
culminated to a final seizure order. A seizure order.
So therefore, my lord, till date, if this email is of 18th March 2024 from CCEOPS, that is the same investigating
I
officer,
know that.
to nodal officer Suryoday
Okay,
Small
we'll
Finance.
simply issue notice, let us inquire. What is happening?
No, but in the meantime, every day, if you want
But what can I do? I can't ask for, I don't know who is the bank, whether, which, the bank has to come at least. Bank has to come and tell us, yes, it is freeze, at which instance, what, I don't know.
I am making a statement that the bar is utmost responsibility that the account has been frozen. That is why he has come before this honorable court.
No, account is frozen in connection to what?
What is?
In connection.
I don't know. It is, everything is, you know, I have only, the what best could be done is, I will issue notice as certain what exactly has happened.
No, but in the meantime, then, my lord, it would be
When according to you, it has been freeze?
18th March
18th of March
2024.
Today, we are in May.
We have to go to
I am issuing notice and on 20th.
I went to the bank. He said your account has been debit free.
Oh, no, it's very oral statement.
One of the co-equals also got convicted, Your Lordship, and the bail already been granted by this honorable court.
Generally, admit to notice, all for LCR,
Good.
stay duration of time amount. So for the, this case is concerned for bail, it is been kept for consideration after decision.
Your Lordship, one of the
It is on
co-equals.
bail, na?
Yes, Your Lordship.
No,
During
this
the,
accused is not on bail.
this accused, one of the co-accused has been convicted in the same case. He has already been enlarged on bail, Your Lordship, by this court. Oh, give me bail.
Let us see.
That I have abode in my para, Your Lordship. In which case,
He is also convicted along with you.
yes, Your Lordship.
Just see, Mr. Maharaj. You are in custody
In a connected case, last
February. You are in custody since February.
Yes, sure.
17
No, I am not in custody, Your Lordship.
Absconding.
Absconding.
Oh. That
Bahare achi.
your friend must be in the custody, therefore.
No. He was also outside. Your
He was
Lordship.
also.
He was also outside.
Yes.
Huh?
See, order is died.
He was absconding. Sure.
Yes.
Here, this man.
No, after dismissal of the appeal, Your Lordship, I preferred this revision, but in the meantime, I have not surrendered before the court bill.
How do you seek parity with this man?
Because,
Ravi Ranjan Thakur.
because both of.
I understand, but he was taken into custody or not?
No, Your Lordship. He
How
was,
do I know? This order doesn't say anything.
because he was not in custody, Your Lordship. That connected case is listed along with this, Your Lordship. Your Lordship.
Then how it is said that petitioner be released on bail?
With he আসছে আজ আসলে তো লিস্ট হয়েছে আসলে তো মিশিয়ে আসছে আজ yes your lordship
Item number
45
45 huh? মাথায় তলতে না 10 আচ্ছা দেখো আর আই দেখো আই এর লেখাই তো তুমি whether you are in custody or not.
তো ওকলাত নাম দেখলে জানা পড়বে
See the IA. Second matter, was he in custody? The order doesn't say anything. How many years you have served? Huh? No, sir, he has undergone about 3 years, 7 months.
yes I have undergone 3 years 4 months your lordship.
So, right on. Mr. Mahapatra, the account for the petitioners, submit, admit, huh? Oh, first admit for the revision admit karo. In so far as I is concerned, call for NCR for the. Mr. Mahapatra, the account for the petitioner submits that his client is in custody since, and his client has already undergone 3 years, 4 months during the trial at the time of during the trial. The co-accused was convicted with the present petitioner has already been enlarged on bail by this court by order dated 19/3/2024, while allowing IN number 203 of 2024 in criminal revision number 110 of 2024. On the ground of parity and on the ground that he has already undergone substantive part of the sentence, he seeks bail. Allowed bail granted. He also allowed bail.
Stay of fine also.
Stay of fine. Stay of fine. Yes. 46. Yes.
Lordship, I am for the petitioner. The petitioner is a reputed playback singer. Lordship, I am challenging the order dated 23/11/2023. The NBW is issued against the petitioner.
You are appearing for a reputed playback singer. You are speaking so slow. You should sing very loudly.
Lordship.
Yes.
NBW issued on 23/11/2023. Anticipated bill was filed and it was rejected, but reference has not been made.
I'll cancel the NVW, let him go and appear. Go and appear. NVW issued on
23/11/2023.
23/11/2023. Yeah. First paragraph anticipatory bail was moved.
It's rejected on 25/8/2020.
He moved an anticipatory application for grant of anticipatory
Yes,
bail, which has been rejected.
But sir, Lordship,
25/8/2020.
Lordship, but on the first day 2023, the interim protection was granted. Lord.
On instruction, the response for the petitioner submits that you will be able to support. When? June or May?
June, Lordship.
June, 15th June.
Lordship.
Okay.
Again, Lordship, we are also challenging the affair also to quash the entire proceeding.
A case of 676 here. He's repeated 2 years. 376 2 years.
Lordship, maybe.
He has not cooperated with investigation, my lord.
That's the problem.
At least he can surrender and avail remedy on the.
Both of you are in the same industry. Why don't you settle on it?
Lordship, the thing is that she works at a bank.
He 39, the girl is 32.
Lordship.
You might have promised to marry.
Yes.
That is alleged in the affair, Lordship.
That's the story.
That has been alleged in the affair. But she has taken money from the petitioner. That has been, they are placed at Annexure 3. She has taken.
Stay for the NBW stay till 30th June.
Yes.
30th June. I am giving enough time.
Lordship.
Try and find out.
Lordship.
So that your arrest issue is not there. At least you got anticipatory bail kind of.
Lordship.
30th June.
No, Lordship, another prayer is there. The quashing of the entire proceeding.
Passing, bring here. Passing the allegations are there. I can't. Insofar as the prayer for passing of the FIR is concerned, the counsel for the petitioner seeks to withdraw this petition to reserving the right to approach this court at appropriate stage. That part.
Police is every day. Police is searching.
I stayed the execution of NBW till June, 30th June. In between, you try and go and meet her and find out solution.
Yes.
Find out solution. You are matured, 39-year-old man. She is also 32. You same profession. Both of you are singer, it seems.
No, Lordship.
She is not
a singer. She works at a bank. I am a singer.
Whatever. Go and sing now in front of her and impress her. If any problem, If there is any chance of settlement, you come and move an application for extension, I'll extend. But settle yourself. That's a better idea. I don't know why to spoil the life. Yes.
47.
After guided for surrender.
Huh?
After we put the court.
30th June, I have stayed the operation of NVW.
Lordship.
That is virtually granting interim
And
protection.
director has given to surrender.
No, he has to surrender 30 June. Oh, no. Yes.
47.
47.
May I please, the petitioner is challenging the order dated 22/9/2015 issued against.
You just simply tell when you got the bail.
Bail, I got the bail on
Which point you're looking at?
20th June 2014.
22/9/2015.
1000. 1000. Yes.
Your Honor, the petitioner is a rustic village lady, illiterate lady.
500. 500.
Oh.
Count 15. Yes.
49.
49 which Pitson টা দেখেন কিছু ইম্পোর্ট অর্ডার নাই
আছে না
খালি Pitson টা দেখেন তাহলে সে এনবিডব্লিউ চ্যালেঞ্জ
NVW. NBW.
ହଁ
ହଁ
1cc କେସ୍ ରେ ଏନବିଡବ୍ଲ୍ୟୁ ହେଇଛି ଆଜ୍ଞା ଆଉ ଗୋଟେ ଫାଇଲ ଧରିଛନ୍ତି
ହଉ ଠିକ ଅଛି କିଛି ଅସୁବିଧା
No, 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 Your Worship, they are holding another file.
ନାହିଁ. It's all right. NBW issued on 13 to 2020. 13 to 2024.
Yes, yes.
Bail.
Bail, Your Worship, 22/7/2016.
এটা abscond on the prayer of IO
No, no,
In the prayer of IO, after see the forward. ठीक है. APS.
23/11/2016 एनबिडब्ल्यू
23/11/2016.
16 NBW.
Yes, sir.
Before you 16.
And bail on 22/7/2016.
1000.
Huh.
1000.
Anticipatory bail lo jayithinu.
1000.
Aye.
Yes.
50.
Wait, let's see.
49 नहीं ला.
49.
50, let's
50.
see.
50.
Yes.
Let's see, bail order 19th December 2012. Now let's see, NBW has been issued on 27 January 2022.
yes
Hello. 27 January 2022.
warrant bail है 10/12/2020
ठीक है. 500. Yes.
51.
My lord, I am repeating on behalf of the petitioner, who is the accused of the GR case number.
bail है 22/7/2003 एनबिडब्ल्यू 14/9/2005
2005.
2005
1000. 1000 each. 15. Yes.
52.
52 मतलब
323,
354
ठीक है.
offense arising out of a complaint case. Bail was granted on 22/7/2003.
Huh?
22/7/2003, bail was granted. Complaint case. 354 is the only non-bailable offense.
You tell me when warrant was.
The warrant was issued on 14/9/2005.
49 2005. 1000.
Obliged.
I may pardon, madam. In the meantime, the case has been committed to the CJM. Now the case is pending.
Which
before
matter?
Item 49. Item 49.
Appear before which court?
CJM.
Appear before in the court of
CJM.
My lord, the petitioner is not on bail and the NBW was issued on 19/4/23
19/4/23.
on the prayer of IO.
Upcoming on the prayer of IO, NBW was issued on 19/3/23.
19/4/23.
500. Yes.
54.
Bail on 22/6/2021, 2021, and NBW 28/8/2023.
22/6/2021 से bail
I don't know why. What is happening to the young people? They are speaking themselves. They are not telling to the court or anyone.
afraid of the court sometimes
जोर है कौन तो?
2023
कौन जोर है?
Again.
NBW issue 28/8/2023.
28/8/2023. Bail
Bail on 22/6/2021.
500.
55.
55. Huh?
55, my lord. Bail on 22/4/2022.
Hmm.
NBW issue 28/3/2023, my lord.
500.
Obliged.
28/3/2023. Here you check for you.
Obliged.
56.
My lord, no, please, your lordship. My lord, he was on bail on 23/2017 and NBW was issued on 23/11/2023.
11/23. Yeah.
My lord.
1,000.
You are very
Then
recent.
you appeared therefore.
No, my lord, very recently. Your lordship may exempt me from the deposit.
What is this? You are praying for
Rabi alias Duryodhan Munda. Your lordship may kindly know from this only.
Rabi?
Alias Duryodhan Munda.
Huh.
From that name, your lordship may know.
Tribal people.
Your lordship may exempt me.
I don't see the name of the accused. I see you. That's the problem.
Tribal people, your lordship has already passed the order in Pokso.
500.
Obligement.
57.
11/4/2020. 11/4/2011 lordship. 11 my notice was issued to the lordship.
Petition रे
11/4/2011 lordship.
22/5/18 लिखा है कैटेगरी तक लिखा है 11/4/2011.
11/4/2011.
correct.
11/4/2011.
NBW 11/4/2011. बेल के भाई लॉर्डशिप बेल के
Where is indicate cost where the notice आई थी lordship 15/9/2009 notice आई थी lordship.
that is on bail. Yes. 1,000.
58.
Petition was on bail since 2010-2020. NBW issued 18/3/2023.
23 na?
Yes, ma'am.
500.
59.
Petitioner was on bail since 26/6/2020. NBW issued 16/8/2022.
500. But what are the Mr. Maharaj, because of the vacation, if I give 30th of May to appear, there may be problem for June for the function. Problem. Otherwise, unless it is remove application, there will be logistic problem, basically. Yes.
60.
NBW issue 9/4/2015. He was on bail 10/2004.
Sorry, sir.
60. Item 60.
60.
NBW issue 9/4/2015, my lord. He was on bail 10/2004, my lord.
4.
4, my lord.
Okay. 15. 5 of 10. 1. Yes.
61.
May I please? Yes.
He was on bail 14th March 2024. And NBW was issued 14/3/24. And NBW was issued 27th March 2024.
24. 2024. Okay. 5. Yes.
On the past day. 62.
Past date.
My lord, NBW whose 8/4/2021. Offense under section 395. Absconded.
On the request of
Co-accused person release bail
on
registration.
the request of IO.
Bail.
No.
It is absconded. NBW was issued on
8/4/2021.
20.
Same day priority by both court.
Okay, 500. Yes.
What is your
63.
My lord, date of NBW is 13/3/2024.
63, ma'am.
Yes, my lord. 13/3/2024. My lord, bail was granted on 8/2/2016. 63.
63.
Yes, my lord. 8/2/2016 bail was granted.
Yes. 500.
More 64.
64. Mr. Behra is appearing for whom?
For state, my lord.
Acha.
63. Mr. Bharat appears.
Okay, okay. Okay.
What are they? 64. Before that, going to that, my lord. That case, my lord, she allowed 370 petition, my lord. But order shows that, my lord, there are, my lord, some ambiguity there, my lord.
Sorry?
That is some ambiguity. I don't put it to Mr. Mishra arguing, my lord. In that case, your lordship directed trial court the petition, I filed 370 petition there. That same may be allowed and the petition will appear before the court below.
Right.
There are some ambiguity because, my lord, the order sheet, my lord, the accused persons, in fact, in that during course, they have been arrested. They are after religion bail. There are charges submitted. They have been summoned by the court below, my lord, to appear the court. Instead of appearing before the court, they filed application here, my lord. That was rejected. Thereafter, they file another application, my lord. For that application, my lord, the directed them, the court, my lord, directed them to file the 205 petition, my lord. That has been rejected, my lord.
Filed and rejected.
Rejected. But how, my lord, 317, who will, my lord, their lawyer before trial court to file the earlier, my lord, during course of investigation, the lawyer was engaged by them.
They'll engage.
But they have to, my lord, comply, my lord, their previous bail will continue, my lord, after submission charge sheet. Then only, my lord,
all the formality will be done in
unless until they appear.
What I'll write is,
my lord,
the trial court will proceed in accordance with law.
my lord. My lord.
Because if the best part is,
my lord,
I have recorded
my lord,
a statement that after committal he will not seek 205.
My lord.
That is very important.
I think, my lord, this matter, my lord, I think, my lord, the matter went to the apex court, my lord. In persons order of apex court, my lord, they have filed 205, my lord. That is my, I have correctly remember, my lord. This matter went to, after rejection of their petition here, my lord, they went to the apex court, my lord. Apex court, while dispensing the SLP, my lord, directed them to avail the opportunity filing 205 petition. And thereafter they filed 205 petition. Unless until their previous bail, my lord, earlier they are during course of investigation, they are on bail, my lord. There were charges submitted. Someone issued to them.
42, right?
42. That is clear, my lord. They may
release it tomorrow.
My senior.
If there is some Supreme Court order, they should have. He should have told me.
My lord, I have, if I am correctly remember, my lord, there are, my lord, they went to the apex court, my lord.
Okay, you tell me tomorrow. I am listing it.
Clear, better. I better. You
are right, absolutely. Mentioning record though. 42 ta order ko rakhi dito, mention kariyo, will clarify. Order kar dito, sign karani.
ए जे तांकर लेखा है पेज बी रे 3/1/2000 CLMC this petition file SLP.
Let us hear from his mouth.
हाँ they ना SLP number देना खाली SLP लिखते
Let us hear from his mouth.
Why should we? मोरे ना माइंड रे डाउट है मुझसे.
नहीं ठीक कल बहुत बढ़िया. हाँ. Yes. Any urgent matter? Oh, so many urgent matters. I'll continue for some time. His matter is because he is in custody. Exam is there.
Yes, my lord.
97. I compromised tomorrow.
Actually,
party man first time SC.
All these matters will be taken up tomorrow.
Yes.
Don't worry about it.
Yes.
72 adjourn.
If the memo will be allowed, lordship, they will bring the file. That is the saying.
What to do? How can I help you?
Diary number is there, my lord.
Unless there are some defective, and there is a notification of this report, my lord.
That's the whole difficulty.
I can only pray, lordship, if registry will be direct after.
How can I, without, you do one thing, I'll put it tomorrow. The first item. Tomorrow is first item. What can I do? Or if you can get it, I will be sitting in my chamber, I will give it to you.
Unless until he has to.
That I am obliged, lord. I'll do that.
Because this boy is examination is there.
Tomorrow is the exam, lordship.
Then there defect is not about defect number he period. That is the notification of.
You should have done it. It's so serious.
My lord, yesterday he is arrested, lordship. Yesterday arrested, lordship.
What exam?
Law exam, lordship. Tomorrow is the exam. That is the.
I'll wait in the chamber. You get it done, and bring him.
Yes.
Bring the matter.
Yes, boss, I'm doing it. I'm doing it.
Without their petition, I can't.
No, no, I'll do it.
At least he should appear again. What is the offense?
Offense is, my lord, 370 and 411. He has been accused in a confessional statement. कि ସିଏ ସାହାଯ୍ୟ କରିଥିଲା ଆମକୁ ଦବାକୁ
ସେଟା ଆଉ ଗୋଟେ ବେଲ୍ ସେସନ ସେ ଫାଇଲ କରି ନବା କଥା ନା ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି ନା
ରିଜେକ୍ଟ ହେଇନି ବେଲ୍ ରିଜେକ୍ଟ
ନାଇଁ I am not going to give bail.
ବେଲ୍ ନାଇଁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇନି ମୁଁ ପରୀକ୍ଷା ପାଇଁ କେବଳ ଅଛି ମୁଁ
482 has invoked
he is in custody
only permission to appear in the examination in the custody.
Yes, Lord.
In the custody, he'll go and appear. What is the big deal about it?
Yes, I've given it.
May I say one thing, my lord?
And get the examination admit card.
Examination I card, admit card and all.
You get it, I'll do it.
If your lordship will direct, then the matter will be come to your lordship's chamber. No, defeat
Ideally speaking, I tell you, ideally speaking, the same day hearing, he should have gone to Chief Justice.
Your lordship also can, since the assignment is before your lordship also can.
So therefore, I'm entertaining because see, these are the situations where if you can't help them, then his career is gone.
Yes, my lord.
His
That-
career is gone.
Yes, Lordship, I'm removing.
Don't waste time. Go and I will wait for you.
I have a item in also 106.
64, my lord.
All the matter will be taken up tomorrow.
It is not urgent. You will ultimately take it after vacation. 106.
106.
The petitioner is there.
Yes.
My lord, item 83 may be urgent.
1 minute. One after another. One after another. Yes, in tribunal to continue. Yes. Yes. Apno kali?
64 tomorrow. 64 tomorrow.
My lord,
Urgent matter tomorrow.
my lord,
64, my item.
If
65.
matters are not urgent, it will be taken up tomorrow.
65 tomorrow, my lord.
Tomorrow, all
Yes,
matters
sir.
will be taken up.
my lord, item 83 may be urgent.
80?
3. Yes, ma'am.
Tomorrow.
After vacation.
Any other matter? Go and
I'll just take that memo. They will not be the file and put up to chamber. That is what I'm saying.
otherwise you can go and mention before Chief Justice also. He may assign to anyone. That's a better idea.
No, no, my.
Go and get it.
sir 100 item